Good day to you, Doctor. We are from Group 7, and the topic of our infographic is illegal gathering. My name is Wong and my memory number is 269547. Firstly, I'd like to present the introduction of our infographic. In Malaysia, legal gathering is the same as the unlawful assembly. According to the Lord Hawkins, unlawful assembly is defined as a meeting of many people which would cause damage to the public peace for recovering their interests. It is important to emphasize that in Article 10, Clause B of the Federal Constitution, it states that every Malaysian is given the right to assemble peaceably without arms. However, the gathering or the assembly will be unlawful if it is not in accordance with the law. According to the Section 141 of the Penal Code, it states that the assembly is considered unlawful if it consists of 5 people or more than it, and if the purpose of the assembly is to subsection A, to prohibit public servants to execute their duties by using criminal force, subsection B, to oppose any law or legal process to be executed, or subsection C, to commit any criminal offense such as mischief or criminal trespass, or subsection D, to deprive the right to property of any person by means of criminal force. And lastly, the subsection E, to compel any person to commit unlawful offense by means of criminal force. This is the definition of the illegal gathering or unlawful assembly under Section 141 of the Penal Code. Now, I'd like to pass the floor to my groupmate, Goh Yong Han, to continue. Thank you.
Good day, madam. My name is Goh Yong Han with mention number 269579. In pertinent to the question, who will be deemed as a member of unlawful assembly based on section 142 of Penal Code, a person is deemed to be a member of unlawful assembly if he or she is aware that the assembly would be rendered unlawful, but he or she still continues to join the unlawful assembly intentionally. In this regard, Section 143 of Penal Code stipulated that any person who is a member of unlawful assembly shall be punishable with imprisonment for a term which may extend to 6 months or with fine or with both. Furthermore, a person is said to be liable under Section 145 of the Penal Code if he or she joins or continues in an unlawful assembly that has been ordered in a manner prescribed by the law to disperse. Then, the person shall be liable for imprisonments for a term which may extend to 2 years or with fine or with both. That's all from me. Now I shall pass the floor to the next presenter. Thank you.
Good day everyone, I'm Kara Hill with metric number 270949. Moving on to section 149 of the Penal Code. According to section 149 of the Penal Code, it provides that if a person has committed an offense which is the gathering purpose, the rest of the members will be jointly liable. I give you an example of the case called Muhammad Haikal versus Public Prosecutor. So in this case, the appellants killed a member of their school during a fight. The disease was not even retaliating. The court eventually held that there was a joint liability under section 149 of the Penal Code because the appellant have common object which is to cause grievous hurt to the disease which was likely to cause death. And then section 151 of the Penal Code provides that if a person knowingly that the assembly that he is going to join is likely to cause public disturbance, but he or she still joined it, and after that the assembly was commanded to be dispersed, meaning to say the assembly was then prohibited under the law, he or she shall be liable for maximum 6 months imprisonment or fine or both.
A very good day to you, Doctor. My name is Lee Gafi, matrix number 270605. In relation to the illegal gathering of Malaysia, it is noteworthy for us to refer to the Peaceful Assembly Act 2012. According to Section 4 of the Act, it stated that a person would be deemed to commit an offence if he organizing an assembly if he is not a citizen of Malaysia, or he is below the age of 21 years old, or he organized the assembly in a prohibited places. Apart from that, the Peaceful Assembly Act 2012 has also outlined some responsibilities to be followed by the organizers and the participants. It also conferred the right to the police to take necessary measure in order to make sure the properly conduct of the assembly itself. If we refer to the Section 6 of the Peaceful Assembly Act 2012, it stated that an organizer shall have the responsibility to ensure no person in his assembly have a tendency to disturb the public tranquility or commit any offense under any written law. It also needs the organizer to ensure that his assembly would not cause any damage to the property or environment as well as significant inconvenience to the public. Lastly, the organizer shall also be responsible to clean up the location after the assembly had been taken place. Moving on to the responsibilities of the participants, according to Section 7, it stated that the participants shall refrain from any conduct in disturbing any assembly from taking place, or behaving offensively towards any person, or cause hostility amongst the public, or commit any offense that would cause damage to the property. In any event of the non-compliances aforementioned had been taken place, Section 8 of the Peaceful Assembly Act 2012 conferred the rights to the police officer to take measure that he deemed necessary to ensure the orderly conduct of the assembly. With that being said, any failure of the person, either organizer or participants, in compliance with the responsibilities stated under the Peaceful Assembly Act, it would result them to be liable to legal consequences as well as the enforcement of police. With that, I end my part. Thank you.
Good day, Doctor. I'm Teo Kai Jue with metric number 270756. I'm going to discuss about the part 4 of the PAA. So according to section 9, the notification to the OCPD shall be made by the organizer 5 days before the date of the assembly. Before that is 10 days prior to the assembly. But after the amendment made in 2019, it has been amended to 5 days prior to the event. This notification must comply with the requirements under Section 10, which includes a copy of consent of the owners of the assembly place, relevant details of the assembly stated under paragraph E, and any other additional details as required by OCPD. This is very essential because it would enable the police to make the necessary plan and preparation to preserve the public order. So, in line with Section 12, notification to the person who has interest shall be made by the OCPD within 24 hours upon receipt of the notification made under Section 9. For example, if the police were told that an assembly will be held at the KL Street, the police shall notify the DB KL as it is the person who has interest to the KL Street. After the OCPD receive such notification, he shall also notify the organizer with regard to the conditions and restriction in order to prevent the riots and those disturbance to the public. So, with regard to the punishment, failure to comply with Section 9 and Section 15 shall be liable to fine maximum 10,000 ringgit if convicted, while Section 4, Subsection 4 also stipulates that bringing a child to the assembly shall be liable to 20,000 ringgit if convicted. So, if the assembly is ordered to be dispersed, but the members of the assembly refuse to do so, it shall be considered as an offense as he shall be liable to a fine maximum 20,000 ringgit if convicted. That's all from me. Thank you.